Welcome, everyone, to the 24th Annual Frank M. Coffin Lecture on Law and Public Service. Thank you all for being here this evening. My name is Danielle Conway, and I am the proud Dean of the University of Maine School of Law. Each year, the Judge Frank M. Coffin Lecture on Law and Public Service provides us an opportunity to reflect on our individual and collective commitments to doing justice in our society. The Coffin Lecture also reminds those of us who are judges and lawyers that our community members are equal partners in the passionate pursuit of justice through service to the public. In this way, the Coffin Lecture is for and about all of us. It is a calling to each of us to fulfill the challenge that Judge Frank M. Coffin issued to us to pursue justice in whatever sphere of influence we each have, from grassroots efforts to institutional initiatives. The introduction speaker, Chip Lowenson, and our keynote speaker, Margaret Groban, are both shining examples of Judge Coffin's legacy, the creation of a network of people with broad and far-reaching talents who are all committed to walking on the path of justice. Like Chip and Margaret, there are so many among us tonight on this path. Please allow me to recognize some of those among us who do vital justice work each day. First, I would like to recognize the Coffin Law Clerks who are with us this evening. Please stand. These clerks have traveled from near and far to join us in celebrating the Renaissance man, Judge Frank M. Coffin, and his partner in all he accomplished, Mrs. Ruth E. Coffin, and their children, Meredith, Nancy, Susan, and Douglas, who's traveling. Next, I would like to recognize Maine Attorney General Janet Mills, who was slated to attend but had urgent business, but I still want to recognize her. I now recognize an esteemed Maine law alumna, the Chief Justice of the Maine Supreme Judicial Court, Justice Lee Softly. Please stand. And I learned something at the Maine Judicial District Conference this weekend, that when I'm up on a podium, I can actually tell judges what to do. So I'm going to ask Chief Justice Softly to continue standing, because alongside her, I would like to ask all federal, state, and local judges to stand and remain standing. And finally, I would like to recognize publicly those judges who have served justice in foreign countries who now call Maine home. Please stand. I asked you to be recognized because all of you do justice work, and you make justice work. Thank you, and I applaud each and every one of you. I'm also pleased to recognize my mentor and my friend, President Glenn Cummings. President Cummings is the president of the University of Southern Maine. And I'd like to recognize the University of Maine School of Law team of faculty, staff, and students. Please stand. These students have pledged to defend the Constitution, to promote the rule of law, and to represent those who are less able to represent themselves. And many of them were fortunate enough to meet with Margaret Groban for lunch this afternoon and have their dreams realized, because Margaret told them exactly how to get to where she is. So again, thank you for that, Margaret. One of the many and great privileges of being Dean of the University of Maine School of Law is to officiate over this lecture in honor of Judge Frank M. Coffin. Judge Coffin is one of a select few who served in all three branches of the United States government. He was a member of Congress from the state of Maine for 4 years in the late 1950s. He and the late Ed Muskie, first a senator and then Secretary of State, founded the modern Democratic Party in the state of Maine. Frank Coffin, not yet a judge, ran for governor in 1960. Although he came in second, he received more votes in Maine than did John F. Kennedy. He served in the Agency for International Development until 1965, when President Kennedy appointed him in the United States Court of Appeals for the First Circuit. Judge Coffin served on the court for 40 years, 11 of those years as Chief Judge. Judge Coffin was always a staunch supporter of Maine law, but more than that, Judge Coffin groomed young people for careers aimed at lifelong service to the public. Our introduction speaker, Chip Lowenson, is counted among Judge Coffin's finest mentoring achievements. The 24th annual Frank M. Coffin keynote speaker, Margaret Groban, will be introduced by her friend and former colleague, Chip Lowenson. Margaret Groban and Chip worked together in the United States Attorney's Office for the Southern District of New York for 5 years. They began their life of service as prosecutors in that office within a few months of each other in 1985. Chip will tell you more about Margaret, and now I will tell you a little more about Chip, or as I have come to fondly know him, El Chipito. Before clerking for Judge Coffin from 1983 to 84, Chip graduated from Princeton and then Yale Law School. After his clerkship with Judge Coffin here in Portland, for 1 year he was the Karpatkin Fellow at the American Civil Liberties Union, where he worked on the national legal staff. From 85 to 90, he served with Margaret Groban in the United States Attorney's Office, where he prosecuted mostly insider trading and other securities fraud cases. Since 1990, he has been at the New York City office of Morrison Foerster, where his practice has focused on white-collar criminal defense. For 6 years, he served on the New York State Ethics Commission, and later served another 6 years as chair of the board of the Jacob Javits Convention Center in New York City. His wife, Susan Brune, also worked in that same U.S. Attorney's Office and now has her own law firm. Chip and Susan have 3 children, one aged 19 and 16-year-old twins. Chip had a life-affirming personal and professional victory earlier this year, when his pro bono client, Richard Rosario, was freed from prison after Chip and others at his firm worked for 13 long years to secure Mr. Rosario's exoneration. Mr. Rosario had served 20 years in prison for a crime he did not commit. The case was featured by Dateline NBC and the NBC Nightly News with Lester Holt. Securing freedom for an innocent person wrongly accused and incarcerated is the pinnacle of achievement for any lawyer. While I know Mr. Rosario is beholden to Chip for restoring his liberty, I am beholden to Chip for serving nobly and bringing back that nobility to our profession. I now welcome you, Chip Lowenson.
Thank you, Dean Conway, for that very nice introduction. We have a lot of distinguished guests in the audience this evening. We have some elected officials, many judges, other public servants, and many esteemed members of the bar. I want to recognize only one of our distinguished guests this evening, and that is the indomitable Ruth Coffin. It was wonderful to catch up earlier today at the Coffin House with Ruth and with Nancy, Meredith, and Susan. And I'm pleased that so many of the judges' former clerks are here this evening as well. We consider ourselves part of the extended Coffin family, and November is a good month for family gatherings. The Coffin clerks are known collectively as the clever. And we collectively helped to establish the Coffin Lecture on Law and Public Service to honor the judge and to celebrate his values and his devotion to justice. For the first 15 years or so of the Coffin Lecture, the judge himself would deliver his signature introduction, and I don't know if there's any former Coffin lecturers in the audience, but you'll forgive me if I say that a lot of people came to hear the judge give his introduction. And I will not even try to imitate his wit and his charm. I will tell you that, as many of you know, the judge possessed an astonishing intelligence and wisdom and an abiding commitment to social justice and public service. I know there's a lot of people in the room who, like me, very much miss his warmth, his kindness, and his wit. I also know that the judge would have been delighted with the selection of this year's Coffin lecturer, Margaret Groban. But before I tell you more about Margaret, a couple more introductions. Here in the front is Margaret's mother, Irene Groban. Also here tonight is Margaret's sister, Betsy Groban, Margaret's husband, Dr. Larry Fishman, and two of their three daughters, Elizabeth and Victoria. Their eldest daughter, Rebecca, is hard at work in New York City. She couldn't be here tonight, but she wants everyone to know that she's just as proud of her mom as are her two sisters. And I want to tell you a little bit more about Margaret's mother, Irene. You may have heard that we have an election coming up in this country next week. And I won't say how Margaret's mom is going to vote next week, because we still have a secret ballot. I can say that, like Judge Coffin, Margaret's mom cast her very first vote for president for Franklin Roosevelt. I can also say that Margaret's mom is a proud Wellesley graduate, and she has a deep fondness for Wellesley, but I won't go beyond that. So now I want to focus a little bit on Margaret. Margaret and I worked together for 5 years in the U.S. Attorney's Office for the Southern District of New York. Margaret, from the beginning, was a fantastic prosecutor. She was a hard worker. She was committed to the job. She was always willing to pitch in. and she was never, ever afraid to take a tough case to trial. She's now in her 32nd year of service in the United States Department of Justice. About 20 years ago, she and Larry moved the family from New York City to Maine, and that's about all you need to know about her excellent judgment. Margaret now has an office here in the U.S. Attorney's Office in Portland, but officially she's the domestic violence coordinator in the Executive Office for United States Attorneys. The Executive Office is the coordinating body for the 93 U.S. Attorney's offices around the country. Multiple sources, as I did my research, told me that Margaret is the leading subject matter expert in the United States Department of Justice on domestic violence. She is a sought-after speaker and instructor, both inside and outside the Justice Department, on all issues relating to investigation, prosecution, and prevention of domestic violence. She's involved in all of the important policy discussions in the Justice Department on domestic violence, and she reviews proposed legislation related to domestic violence and violent crime. Margaret has worked closely with the department's appellate attorneys, including the Office of the Solicitor General, in preparation of briefs and oral arguments in the District Court, Courts of Appeals, and including the United States Supreme Court. And you'll hear more about the work from Margaret, about the work that she did on 3 recent successful cases in the United States Supreme Court. Going back many years, as many of you know, federal law has barred convicted felons from possessing firearms. In an effort to close what Congress called a dangerous loophole, Congress extended the ban on firearms possession to persons convicted of a misdemeanor crime of domestic violence. And Margaret has been a leader at the Justice Department in ensuring that this dangerous loophole remains closed. And as many of you know, and it's probably no coincidence because Margaret works in this district, the U.S. Attorney's Office for the District of Maine has been one of the nation's leaders in enforcing the federal firearms laws against domestic abusers. The Supreme Court decision in June of this year in Voisin versus United States and its companion case Armstrong versus United States both involved prosecutions in this district. Margaret was involved in those cases from beginning to end, from the charging decision to the trial preparation to the briefing in the Court of Appeals, and including the preparation of the briefs and the arguments in the United States Supreme Court. Because of her work on those cases and many other cases around the country, several of her colleagues told me that Margaret has been a major contributor to the federal government's ability to keep firearms out of the hands of domestic abusers. So when I thought about Margaret's career of law and public service, her easy collaboration with her colleagues, her qualities as a teacher and a mentor, I realized that she reminded me of someone, and that someone was Judge Coffin. Margaret, you should know that the judge would admire you and your work. He would see you as a fitting Coffin lecturer, a perfect representative of law and public service. That is the enduring theme of this lecture and of the judge's lifetime of work. Like you, the judge was a great teacher, a great collaborator, often working quietly behind the scenes and contributing his intellect, his energy, and his devotion to the cause of justice. So Margaret, in just a minute, I'll let you tell us about your work. But first, I want you to hear what some of your colleagues in the Justice Department told me about their admiration for you and for your dedication to your work. And I'm going to read to you some exact, direct quotations from some federal prosecutors. This work is a passion for her. She is revered. She is an utter pleasure to work with. She is an amazing prosecutor. She is always on the cutting edge. I know I can trust what she says without having to verify. And this last one is my favorite. She is the real deal. So it is my pleasure and privilege to introduce the real deal, Margaret Groban.
Thank you very much, both Chip and Dean Conway, for the introductions. It seems like only yesterday that Chip and I were baby prosecutors in Manhattan. In fact, Chip was the first of many impressive Coffin law clerks that I have met over the years, so I very much appreciate his willingness to travel north here tonight. And in addition, if I remember correctly, Dean Conway spoke about your work in securities fraud, but if I remember early on in our tenure, you brought a racketeering case before any of us knew what racketeering meant against defendants who were exploiting and prostituting women who were smuggled into this country. So Chip was a champion of violence against women before I even knew what it was. So thank you, Chip. I am thrilled, honored, and humbled to be selected as this year's Coffin Lecturer, and it was also very much an honor for me earlier today to meet Ruth Coffin and the Coffin family. I was fortunate to have met Judge Coffin. As Chip recalled, we worked together in the Southern District of New York before I moved up here with my husband and 3 children in 1996. My last trial was before Judge Danny Parker, then on the Southern District bench and now on the Second Circuit. When I stopped in to say goodbye to him, it was a very collegial court, not what people might think about New York, and he learned I was moving to Maine. He said that I had to meet the legendary Judge Coffin. He had befriended Judge Coffin through their work on the Governance Institute, a nonprofit organization concerned with the nexus between law, institutions, and policy. He raved about Judge Coffin as a scholar, a judge, a gentleman, a friend, and an extraordinary man. Luckily, I got to experience some of these qualities for myself. Soon after I moved to Yarmouth, I called Judge Coffin's chambers to arrange for a meeting, and he could not have been more gracious to spend time with a new lawyer in Maine. I can't remember all of my conversation with him in his chambers, but I vividly remember his advice and his guidance. Make sure that I contribute to social justice in Maine, and he had numbers of names of people if I needed some help in doing that, and to appreciate the importance of public service. I guess I took his advice to heart, since I have continued as an assistant U.S. attorney and have dedicated my career to the pursuit of justice. The Department of Justice, or DOJ as we call it, means just that to me, a commitment to providing justice for all. The more I read about Judge Coffin, the more impressed I am. Justice Breyer's description of him in the Maine Law Review as thoughtful, intelligent, learned, kind, and decent is just the beginning, as he goes on to comment that Judge Coffin's work reflects an understanding of and sympathy for the human problems that underlie the cases that make their way to the courts of appeal. It is the human problems that are so important to me as a federal prosecutor. From previous Coffin lecturers, it is evident that there is no one way to achieve Judge Coffin's pursuit of social justice and public service. The path for justice that brings me here tonight is the dedicated DOJ effort to keep firearms out of the hands of domestic abusers and save lives of domestic violence victims. This quest has lasted 20 years and involved assistant U.S. attorneys in U.S. attorneys' offices around the country, but particularly in Maine, as well as lawyers at the Department of Justice in the Criminal Division, the Criminal Appellate Division, and our Solicitor General's office, which is the office that represents us before the Supreme Court, but also rules on our appeal authorizations. It has taken this national village of prosecutors to achieve the success that we have achieved, one case at a time, one brief at a time, one appeal at a time, and one legal issue at a time. And we are anchored by our law enforcement partners, both at ATF and FBI, who refer the cases to us. And I would be remiss if I did not give a shout out to the FBI and ATF agents in the Maine offices whose dedication to prosecuting domestic violence abusers and keeping victims safe is without comparison in the country, although I admit I am biased. So why is the federal government involved in the fight against domestic violence? DOJ is resolved to reducing violence in our communities, but safety in our communities must begin with safe homes. We know that home is not a safe place for too many people. Domestic violence is a national crime problem that knows no boundaries. It impacts people of all races, colors, creeds, nationality, religions, and sexual orientation. It impacts the rich and the poor and the middle class. It is clearly an equal opportunity crime. Here are just a sampling of some of the dramatic statistics documenting the scope of the domestic violence problem. The FBI recently released statistics for 2015. In that year, 1,719 women were murdered in the United States. And of those women murdered, 509 were wives, 496 were girlfriends. So 58%, over half of the women killed in the United States, are killed by their intimate partners. Women are killed by someone who they love. Why do we focus on guns in domestic violence? The statistics that the Department of Justice released for trends from 1980 to 2008 show that over 2/3 of victims murdered by a spouse or ex-spouse are killed by guns. In 2008 alone, over half, or 53% of women, were killed with guns. That is why we focus on guns and domestic violence. Also, as a leading scholar in the field has found, when a gun was in the house, an abused woman was 6 times more likely than other abused women to be killed. So what do we want to do? We want to get guns out of these houses. The domestic violence problem in Maine is equally stark and tragic and presents one of our most obstinate crime problems. This has been reinforced during my years on the Maine's Domestic Violence Homicide Review Panel, where we confront the human face, as Judge Coffin would have liked, behind domestic violence and strive to improve Maine's response. Unfortunately, like the rest of the country, women in Maine are far more likely to be killed by someone who claims to love you. Domestic violence in Maine. Over the last 10 years, almost 50% of the homicides in Maine are domestic homicides. For the period 2014 through 15, there were 45 homicides in the state. 55% of them were domestic homicides, and 60% of those domestic homicides were committed with a firearm. The Maine Coalition to End Domestic Violence provides resources to domestic violence victims around the state. Over 13,000 people in Maine used their services in 2015. And legal advocates and attorneys provided over 17,000 hours of legal advocacy on behalf of these people seeking resources. So if anyone in the room is one of those legal advocates and attorneys, I thank you. Against these staggering statistics, isn't it imperative that the Department of Justice play an important role in keeping firearms out of the hands of domestic abusers to keep their victims safe? Chip has alluded to the fact that there are 93 U.S. Attorney's Office, and EOUSA, Executive Office for U.S. Attorneys, is the umbrella agency for all of them. My litigating days are behind me, and I now work for EOUSA as a subject matter expert on domestic violence and firearms. But most importantly, my role is to ease the burden on federal prosecutors who are prosecuting domestic violence and firearm cases, and to encourage and facilitate the prosecution of these cases. In a way, my job is part air traffic controller, consigliere, and advocate. I keep track of all the cases. I encourage and support their efforts in any way possible, and even when we are faced with overwhelming odds against our success. I connect AUSAs facing similar issues around the country, and I encourage consistent national litigative strategies. I console when we lose, rejoice when we win, and try to get everyone home safely. I provide training, guidance, legal updates, webinars, briefs, or any other support that will advance our commitment to fight domestic violence and also facilitate engagement with the local domestic violence community in each federal district. And if that job doesn't sound cool enough, at least to me, I have the luxury of fulfilling my responsibilities while sitting actually in the Maine U.S. Attorney's offices. My commitment began soon after the Violence Against Women Act, which is known by the awful acronym VAWA, was passed in 1994, and I worked on one of the first VAWA criminal prosecutions in New York. I had prosecuted many different types of cases, from drug trafficking to organized crime to fraud, but it was my exposure to the tragedy of domestic violence that chartered my future career path. After I moved to Maine, I was appointed as the National Domestic Violence Coordinator, a position I still hold today. When I'm asked why the federal government is involved in what is primarily a state, local, and tribal matter, the answer begs another question. Why weren't we involved sooner? The basis for jurisdiction is neither novel nor creative and relies upon traditional interstate commerce or travel. We prosecuted interstate transportation of stolen property, but not interstate travel to commit domestic violence. Given the scope of the national domestic violence problem, does this make any sense? Well, VAWA closed this gap. Now it was up to the U.S. Attorney's offices to ensure that federal domestic violence cases, which were admittedly unusual terrain for federal prosecutors, were prosecuted. I recognize that the vast majority of domestic violence cases will still continue to be prosecuted in state, local, and tribal courts, but now at least we have specific domestic violence dedicated statutes to supplement, not supplant, existing state remedies. The specific statute I want to discuss tonight is an amendment to the Gun Control Act that prohibits the possession of a firearm or ammunition after conviction of a misdemeanor crime of domestic violence. This statute is Title 18, United States Code, Section 922G9, and it makes it a federal crime, and it's a felony, to possess a firearm and/or ammunition after conviction of a qualifying misdemeanor crime of domestic violence. You see, it's 922G9. This is the 9th category of persons that Congress has deemed too dangerous to possess firearms. The other categories you may recognize are felons, persons involuntarily committed to mental institutions, or persons subject to qualifying protection orders. The statute goes on to define a qualifying misdemeanor as a misdemeanor and a misdemeanor that has as an element the use or attempted use of physical force or threatened use of a deadly weapon committed by a current or former spouse, parent, or cohabitant. And I've highlighted the words in green that we have litigated because we have litigated every one of those words. The statute was passed in 1996, coincidentally the same year I moved to Maine, must have been a sign, at a time when bipartisan legislation was still possible. It passed in the Senate by a vote of 97-2 with 1 abstention. Can you imagine such a thing happening today? It is unheard of, and it speaks to the importance of this statute in addressing one of our nation's persistent crime problems. One advantage of this prohibition is that it may not require the testimony of a domestic violence victim. Possession of a gun and a qualifying conviction may be all you need to convict. This can remove the complicated dynamics that surround these cases. It is difficult enough to be a trauma victim, but imagine if the offender is your spouse, your boyfriend, or your intimate partner with whom you've enjoyed, at least at times, a loving relationship. Upholding the viability of this statute has been a professionally consuming 20-year effort, but this effort also speaks to the dedication of our community to protect domestic violence victims. This includes the victim witness coordinators in each U.S. Attorney's office, like our amazing Heather Putnam, who work directly with domestic violence victims to offer them the support that they need. In particular, the Maine U.S. Attorney's Office, as Chip has alluded, has used this tool and this statute aggressively to fight our local crime problem. And despite being one of the smallest U.S. Attorney's Office, population-wise, we are perennially among the leading U.S. Attorney's offices on raw numbers of domestic cases prosecuted. I hope that my presence in the office has contributed in some part to this achievement, although I do see people running the other way from me from time to time in the office. Almost every AUSA in Portland or Bangor has prosecuted a domestic violence case, and those that haven't certainly won't admit it to me. So why is this statute so important? It prohibits persons from possessing firearms who have already shown a propensity for violence. It also, hopefully, acts as a deterrent to prevent those persons from either keeping or obtaining firearms. It is called the Lautenberg Amendment, after Frank Lautenberg, the New Jersey senator who sponsored the legislation. In the legislation, senators spoke about the need for a statute like this. As Senator Feinstein said, plea bargains in domestic violence cases often result in misdemeanor convictions for what are really felony cases. She went on to say, domestic violence escalates, and it is only a matter of time before the violence gets out of hand and the gun results in tragedy. Senator Lautenberg himself said this amendment very simply would establish a policy of zero tolerance when it comes to guns and domestic violence. There is no margin of error when it comes to domestic abuse and guns. This statute closed a dangerous firearm possession loophole for DV offenders, domestic violence offenders, that were historically convicted of misdemeanors. It is a sad fact in our country that criminal conduct between strangers was, and sometimes still is, treated more seriously than criminal conduct between intimate partners. While the statute seems straightforward, keeping victims safe by preventing their abusers from having guns, implementation and prosecution has been anything but. It has required a tireless fight against constitutional and statutory challenges. The irony of our enforcement effort is a common refrain from some outside of the department challenging our enforcement efforts on existing firearms laws. This refrain ignores the reality of how difficult it can be to enforce existing firearms laws, and 922G9 is a perfect example. It has taken years of diligent perseverance to combat litigation on almost every word of this statute. But fortunately, by 2016, the statute has been litigated not to death, but to life, and now creates an opportunity for all U.S. attorneys' offices to implement nationwide. What are the bases for the challenges? Well, I don't want to get too far into the legal weeds, and I apologize in advance to the non-lawyers in the audience, including my friends and my family. But these legal challenges go to the heart of our ability to prosecute these cases. Let's start with the Second Amendment. There's a lot of discussion about what the Second Amendment is and what the Second Amendment isn't. The Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Until 2008, the right to bear arms was considered a collective and not an individual right. That changed in 2008 when the Supreme Court decided District of Columbia versus Heller and found an individual Second Amendment right to bear arms. This core right extends to the defensive use of firearms by law-abiding, responsible citizens. The Keller Court, however, specifically recognized and made clear that the right was not unlimited and that certain categories of regulation are presumptively lawful. Not surprisingly, Second Amendment challenges to 922G9 followed Heller. The seminal case was a 2010 en banc decision by the Seventh Circuit in United States versus Scowen. This case was argued by the Deputy Solicitor General, who normally represents us before the Supreme Court, but chose to argue this appeal before the Circuit Court. And what did Stephen Scowen do? I always think it's so important to look at the facts of an underlying case, to look at the human face behind it. In 2003, Stephen Scowen pushed his wife down on a gravel driveway, injuring her hands, and he can be heard in a 911 call threatening to kill her. In 2006, now he is involved with his fiancée. He is no longer married, but his new fiancée believes he is attempting to run her off the road, so he ran up to her outside the house, pushed her down, causing her to hit her head on her car. In constitutional cases, the important question is what standard of analysis governs the challenges. In Scowen, the court held that intermediate scrutiny governed the Second Amendment meaning that the government has to prove a substantial relationship between the statute charged on the one hand and an important governmental objective on the other. The Scowen Court wrote, "No matter how you slice the data, people convicted of domestic violence remain dangerous to their spouses and their partners." The court upheld the constitutionality of the statute against a Second Amendment challenge and said no one doubts that the goal of 922G9, preventing armed mayhem, is an important governmental objective. Both logic and data establish a substantial relationship between 922G9 and this objective. A year later, the First Circuit weighed in and agreed with the Seventh Circuit analysis and rejected a Second Amendment challenge. The court in U.S. versus Booker wrote that the presence of a gun in the home of a convicted domestic abuser is strongly and independently associated with an increased risk of homicide. The court also noted that removing guns from the home will materially alleviate the danger of intimate homicide by convicted abusers. The Booker Court also expressed no doubt of a substantial relationship between the government's objective of 922G9 and the statute. This is not surprising for either the Seventh or the First Circuit, based on all the data establishing the dangerous connection between domestic abusers and firearms. So while the Second Amendment challenges around the country failed and were fairly straightforward, battle was joined on the qualification of a misdemeanor crime of domestic violence. It is this statutory fight that has consumed the efforts of U.S. attorneys' offices around the country. So what is a qualifying crime? And unfortunately, common sense cannot be your guide. To begin, does the underlying misdemeanor crime need to be a specifically designated domestic violence offense? Many of you know that states have both general domestic violence crimes and then specific domestic violence crimes. The Supreme Court, in one of 3 cases in which the court has addressed this statute, resolved the issue in 2009 in United States versus Hayes. Randy Hayes had been convicted in West Virginia of battery against his wife. Years later, the police responded to a domestic violence call to his house. The obvious potential for danger with guns and domestic violence. He was indicted under 922G9 and challenged the qualification of his battery conviction, saying that since it did not qualify because it was not a specific domestic violence crime. He lost in the district court but appealed, and the Fourth Circuit agreed with him and reversed his conviction, finding that because the West Virginia statute had no domestic relationship element, it could not qualify. This holding was at odds with decisions of many other federal courts of appeal. Once an adverse decision is reached, like in Hayes, U.S. Attorney Office appeal is not a foregone conclusion. Support for an appeal must come from the U.S. Attorney's Office, the Criminal Division at the Department of Justice, and ultimately from the Solicitor General's office. This appeal was authorized, and the Supreme Court accepted the case and faced its first opportunity to address the statute. I attended the argument, having been involved in the case from assisting the U.S. Attorney's Office in the Northern District of West Virginia, and then the Solicitor General's office, with compilation of materials and moot court preparation. While you may only remember Citizens United being decided in that term, the Hayes decision has proved influential in its own right. If the underlying crime must have as an element, if you see up here, an element that includes both the use of force and the relationship, then the statute would have been a nullity in 2/3 of the states. In 1996, when the statute was passed, only 17 states had specifically designated domestic violence crimes. In fact, New Jersey, Senator Lautenberg's own home state, did not have a specific domestic violence crime. What we had to keep in mind while we were litigating 922G9 is that a legislative remedy has never been an option. For many reasons, both political and otherwise, we do not expect Congress to revisit and amend the statute to address obvious drafting issues. So the courts are our real last resort. Now let's turn to the argument. Justice Scalia asked the government attorney, and this was misdemeanor assault and battery, wasn't it? Government lawyer, yes, that's right. Justice Scalia, so it's not that serious an offense. That's why we call it a misdemeanor. Government lawyer. Well, I mean, certainly the offense in this case was serious. The charging document reflects that respondent hit his wife all around the face until it swelled out, kicked her all around her body, kicked her in the ribs. Justice Scalia, then he should have been charged with a felony, but he wasn't. He was charged with a misdemeanor. Justice Scalia was absolutely right. This case should have been prosecuted a felony. But misdemeanor prosecutions result from historical undercharging and underpleading of domestic violence crimes that underrepresent the seriousness of the offense. Justice Ginsburg then chimed in. Wasn't the statute responding to just that problem, that domestic abuse tended to be charged as misdemeanors rather than felonies? The whole purpose of this was to make a misdemeanor battery count for the statute's purposes. In a 6-3 majority, and apologize if I get wistful as I think back on when the Supreme Court had a majority of judges, had 9 judges. So this was a time when the vote was 6-3, which equals 9, just saying. The court, we hope that will be remedied at some point. The court reversed the Fourth Circuit and found that the most sensible reading of the statute would allow both generic and domestic violence specific crimes to qualify. Reinforcing the need for the statute, Justice Ginsburg wrote that firearms and domestic strife are a potentially deadly combination nationwide. This victory opened the door to one challenge to the statute. It closed the door to one challenge, but the barn door was blown open by additional challenges. We kept on fighting with one singular goal in mind: keeping victims safe by preventing their abusers from having access to guns. The most common challenge focused on the words physical force. The definition of misdemeanor crime of domestic violence requires use or attempted use of physical force. What does physical force mean in this context? In 2001, in United States versus Nason, the First Circuit, where we sit, faced with a split among Maine district judges in a case prosecuted by the Maine U.S. Attorney's Office, examined the Maine assault statute to determine if it qualified as a misdemeanor crime of domestic violence. The Maine assault statute provides that a person is guilty of assault if he intentionally, knowingly, or recklessly does 2 things: either causes bodily injury or offensive physical contact. The First Circuit found that both prongs, both the causing bodily injury and the offensive physical contact, necessarily require the use of physical force. It is important to note that statutes that prohibit either offensive touching or offensive physical contact are throwbacks to our nation's common law. The actual conduct underlying the offenses is anything but the statutory language must guide our analysis. If only every circuit decision followed the First Circuit, finding that both prongs qualified. But instead, most often other courts of appeals either distinguished or rejected this analysis. For example, both the Ninth Circuit and the Fifth Circuit in 922G9 cases rejected Nason and found respectively that neither offensive touching nor causing bodily injury amounted to physical force. Both courts relied upon hypothetical scenarios that removed physical force from the equation, like offering a poisoned drink or a poisoned cookie. Yes, you should laugh at that. This divorce from reality in these cases is what is most frustrating. Would a defendant who offered a poisoned drink or cookie be prosecuted for assault? I don't think so. Not surprisingly, the defendants could not present any cases supporting their scenarios that they were discussing. In any event, despite strong advocacy and dedication of incredible time and resources by these U.S. attorneys' offices, we were at the end of our rope, and prosecution of 922G9 was effectively dead in both the Fifth Circuit and the Ninth Circuit. The Supreme Court decision in U.S. versus Johnson in 2010 further complicated the issue. This Johnson court was evaluating the Armed Career Criminal Act, a federal statute requiring stiff mandatory sentences for persons convicted of 3 violent felonies. The violent felony definition includes that same language, use or attempted use of physical force, that was found in the misdemeanor crime definition. Justice Scalia wrote for the Johnson Court, "We think it clear that in the context of a statutory definition of violent felony, the phrase physical force means violent force." Unresolved in the Johnson case was whether that rigorous standard imposed for violent felonies would also be applied to the same words, use or attempted use of physical force, in the misdemeanor context. Do the same words have the same meaning in different contexts? I guess that's how lawyers make their living. The answer, unfortunately, was yes in a number of circuits. In United States versus White, prosecuted in the Fourth Circuit in 2010, the court was faced with William White, who was convicted of assault and battery in Virginia. The assault of the mother of his child resulted in a split lip. Although the facts are not relevant to statutory construction arguments, the facts are extremely relevant in the exercise of our discretion to prosecute, so that we focus on prohibiting dangerous abusers from possessing firearms. We want to keep victims safe, and we want to save lives. That is our priority. And William White's criminal history certainly merited prosecution. His criminal history included multiple domestic violence convictions. After the 2004 assault that was the basis of his indictment, he was arrested 2 more times for assaulting the same victim. In the presence of their children, he grabbed her neck, causing her to lose her breath. In the next offense, he pulled her hair, he headbutted her, he bit her, and he threw her to the ground while she was pregnant, a time of particular danger for domestic violence victims. Despite outstanding advocacy by another U.S. Attorney's Office, this time the Eastern District of Virginia, the Fourth Circuit, believing it was bound by Johnson, held that a Virginia battery conviction could not qualify as a misdemeanor crime because it did not require violent force. The loss in White effectively ended prosecutions of G9 in the Fourth Circuit. While we continued to push the envelope, prosecution of this statute was effectively dead in some of the most populated states in the country. It was in this national climate that the U.S. Attorney's Office for the Western District of Tennessee indicted James Castleman in 2008 for violating G9 after he was discovered to be selling firearms on the black market after a 2001 conviction. His conviction in Tennessee was for intentionally, knowingly, or recklessly causing bodily injury to another. It was highly unusual, but the state court documents in his case established that his offense was committed intentionally and knowingly, so the issue of reckless qualification was not raised. What did James Castleman do? He slapped the mother of his child in the face. He dragged her into the house where he slapped her again. He knocked her on the ground. He grabbed her neck and said he was going to kill her and run off with the baby, all while she was holding their baby in his arms. He received an 11-month sentence in state court. The inadequacy of the sentence is an issue for another day. James Castleman is another in a series of examples of defendants who beat their partners, are convicted of misdemeanors, and pose a danger to their victims. The court dismissed the indictment, finding, as the White Court did in the First Circuit, that the use or attempted use of physical force was not met in this case because the statute did not require violent conduct. This was affirmed by a divided panel of the Sixth Circuit, again holding that because the Tennessee statute could be violated without physical contact, again, beware that poison cookie, it certainly falls short of the violent contact required. The U.S. Attorney's Office was determined to remedy this ruling and sought authorization from the Solicitor General's office to appeal. Because of the losses in so many courts of appeal, I advocated along with the U.S. Attorney's Office for Supreme Court review, saying it was necessary to resolve this important issue and keep the statute alive. The news that the Supreme Court granted review in Castleman, although welcome because we desperately needed intervention, was also a scary proposition because we stood to lose the ability to prosecute this statute nationwide. As I have said, a legislative remedy has never been a viable option. Let's look at a map of the country, and it's broken down by the courts of appeal by number. There are 11 courts of appeal. We sit in the First Circuit. It's Maine, New Hampshire, Massachusetts, Rhode Island, and Puerto Rico. So these are the 11 circuits. And going into the Castleman argument, all the circuits in red were where we were unable to prosecute 922G9, and the Second Circuit was a little iffy. So we stood to lose all of these if we lost in Castleman. But our team kept a singular focus and understood the importance of this statute in potentially saving victims' lives. With a keen understanding of the stakes, that we stood to lose even more circuits, I attended the Castleman argument before the Supreme Court on January 15, 2014. As is always the case, after participating in several moot court arguments, providing volumes of material and data, in addition to their own extensive research and briefing, the government lawyer could not have been more prepared. As she argued, the defendant's argument would indisputably exclude the assault and battery statutes of almost all of the 50 states and the District of Columbia. It would leave that dangerous loophole wide open. Approximately 2 months after argument, on March 26, 2014, the Supreme Court reversed the Sixth Circuit and held that the Tennessee assault statute qualified. Justice Sotomayor wrote for a unanimous 9-person court and began by reviewing the legislative history and powerful statistics establishing the dangerous connection between firearms and domestic abuse. She wrote that this country witnesses more than 1 million acts of domestic violence and hundreds of deaths from domestic violence. Each year, the presence of a firearm increases the likelihood that it will escalate to homicide. She also quoted Senator Wellstone, "All too often, the only difference between a battered woman and a dead woman is the presence of a gun." The Supreme Court refused to extend the Johnson requirement of violent context to the misdemeanor context. Context is critical. It makes sense that the court would not apply to misdemeanors a definition of physical force that applies to violent felonies. In addition, the court held that the physical force needed for 922G9 is satisfied by the force used in common law battery, which includes both causing bodily injury and offensive contact. Since almost all state assault and battery statutes cover these two prongs, this decision reinvigorated our ability across the country to prosecute the statute. It recognized that hitting, slapping, shoving, grabbing, pinching, biting, and hair pulling are all typical forms of domestic violence. But Castleman was also a clarion call to federal prosecutors to use this statute to address the horrifying statistics recounted in their opinion and to keep victims safe. And we have continued to heed this call. While we rejoiced at this decision, our celebration was short-lived once we read the whole thing. In footnote 8 of the opinion, Justice Sotomayor noted that this case did not resolve the issue of whether or not a statute violated recklessly could qualify as a misdemeanor crime of domestic violence because Castleman had pled guilty to a knowing and intentional act. But the footnote noted that every court of appeals, except the First Circuit, and I thank the First Circuit very much, had ruled that recklessness was not sufficient in other contexts. But why do we even look at recklessness when the facts establish intentional and knowing conduct? Because neither the facts nor the prong of conviction is necessarily included in the charging documents. So we have to assume the lowest level of criminal culpability in the statute. In the Maine statute, the lowest culpability is reckless offensive physical contact. So there was no rest for the weary. In no time, defendants were following the lead of this footnote and attacking statutes allowing for the reckless commission of crimes. So despite the Supreme Court wins in Castleman and Hayes and our Second Amendment victories, it felt like we were back to square one. We were opening up the map again, fighting to preserve 922G9, since it turned out that a majority of states had assault and battery statutes that included reckless conduct. The challenges against statutes that allowed reckless conduct brought us back to the Supreme Court for the third time in 8 years. While it is certainly a professional thrill to be intimately involved in 3 Supreme Court cases, each time the stakes were so high, I could barely sit back and enjoy it. And in the 3rd Supreme Court case, the underlying prosecutions were brought by our own U.S. Attorney's Office sitting in Bangor. Stephen Voisin was convicted in 2004 of violating Maine's assault statute. He was found in 2009 with a firearm after he admitted killing a baby bald eagle, also a federal offense. Most people go, oh, when they hear about the bald eagle. But what had he done? His victim had called 911 because Voisine, her boyfriend and cohabitant for 7 years, had slapped her in the face across the cheek. She said he was drunk and this was not the first time it had happened, but she added he's not usually like this except when he drinks. His criminal history spanned 28 years and included 14 convictions, including multiple convictions for violation of a protection order. The 2004 assault conviction that was basis for our case against the victim was followed by a 2005 domestic assault conviction. William Armstrong was also prosecuted in our Bangor U.S. Attorney's Office. And what did he do? While his wife was baking cookies, he got mad at her because she wasn't wearing her wedding ring. He pushed her. She told him to stop. The two argued. He got mad and he slapped her, and then he hit her again, but harder this time. Knowing these facts makes firearm disbarment all the more important. The defendants entered conditional guilty pleas, and their convictions were affirmed by the First Circuit. These cases were consolidated, and after many fits and starts on appeal, Supreme Court review was granted, even though there was not a deep circuit split. This is not necessarily a positive sign, since the Supreme Court's commitment to allowing reckless misdemeanors to qualify was uncertain based on that footnote in Castleman. This process, like all the other cases that wound their way from the district court to the Court of Appeals to the Supreme Court, require enormous U.S. Attorney Office resources, not only by the AUSAs in district court, but also by our appellate lawyers. Mark Terrison spent too many summers briefing and arguing and prevailing in 922G9 cases before passing the torch to Renee Bunker, who also spent incredible amounts of time briefing and prevailing and arguing 922G9 cases, all with the support of Appellate Chief and Coffin Clerk Margaret McGoy. It reflected both the Department of Justice and the Maine U.S. Attorney's Office commitment to saving lives by preventing access to firearms by domestic abusers. Once the Supreme Court accepted the case, we all moved into high gear. The Voisine consisted of Renee Bunker, who had argued the cases in the First Circuit, the criminal appellate unit, an amazing team from the Solicitor General's office, and me representing the U.S. attorney community. We tracked down every case, every statute, and every argument. I also met with the amici from domestic violence organizations, law enforcement organizations, and gun organizations, most of whom, not all, filed very powerful briefs in support of the government. Argument was held on February 29, 2016, within a week of Justice Scalia, of the death of Justice Scalia. His chair was still draped in black. As expected, the argument focused on whether a reckless conduct statute can qualify as a misdemeanor crime of domestic violence. We argued powerfully that whether an assault is committed recklessly or not should not matter. Since Maine defines recklessness as the conscious disregard of a substantial risk, that level of intent is consistent with dangerousness and firearm disbarment. The argument did have a surreal moment at the end of the government lawyer's argument. Elena Eisenstein was arguing for us about how important the statute is, and at the end she says if there are no further questions, generally the time where the appellate lawyer knows the argument is over, they can take a deep breath and they can sit down. But this time Justice Thomas leaned forward and asked his first question from the bench in 10 years. Although it dealt with the Second Amendment, an issue which the court had specifically excluded from review because the law is well settled, the hush in the courtroom was remarkable. The court waited to torture us until the last day of the 2016 term to issue a decision, and it did that on the last day, and it was a resounding 6-2, which equals 8, win for the government and affirmation for the First Circuit. Repeating the findings of both Hayes and Castleman, Justice Kagan wrote, "A person who assaults another recklessly uses force no less than one who carries out that same action knowingly or intentionally. Because fully 2/3 of the states extend laws to recklessness, construing 922G9 to exclude crimes committed with that state of mind would substantially undermine the provision's design. Accordingly, the Supreme Court held that the Maine assault statute, even with its reckless component, qualifies as a predicate under the statute. As if to prove his worth as a prosecutive target, William Armstrong's ongoing domestic conduct continued. Judge Woodcock noted in a 2015 opinion issued in another pending 922G9 case that even while his appeals were pending before the Supreme Court, he was arrested and subsequently convicted in Maine State Court of yet another misdemeanor crime of domestic violence after his wife was found hiding in the woods after an assault. And tried as I could to get the Solicitor General's office to get that fact before the Supreme Court, they were right. It was not in the record, and so the Supreme Court did not know about it. But Justice Judge Woodcock wrote, "With people like Mr. Armstrong in mind, it is difficult to argue against the legislative judgment that Mr. Armstrong and people like him, who cannot stop assaulting their domestic partners, have ceded their constitutional right to possess a firearm and instead have earned prosecution, conviction, and punishment when they possess such weapons." Amen. Is the litigation over? Is there more to contest? Hopefully not. We hope that U.S. attorneys' offices around the country can now take a deep breath and now devote their efforts to prosecuting cases that reap enormous benefits for our victims, their families, and our communities. Again, our communities will not be safe without safe homes. On a personal note, I have been fortunate, and I hope the aspiring and young lawyers in the audience will be as well, to find a niche where you could pursue both social and legal justice within your community. This continues to be a learning experience for me as I navigate the complicated and treacherous waters of domestic violence. I no longer ask why victims stay in dangerous situations. Having never walked in their shoes, we are in no position to judge. But we can increase their safety by holding abusers criminally responsible and trying to ensure that they do not have access to firearms. If there is a moral to this story, let it be that perseverance and dedication, when combined with passion for a just cause, regardless of the odds or the setbacks, can bear fruit in the long run. It has taken 20 years and the amazing contribution of our Department of Justice Village, but we have prevailed challenge by challenge, case by case, defendant by defendant, in our pursuit to make Maine and the country a safer place for domestic violence victims. Thank you. You don't have to get up. Thank you.
What other tools would assist in this ongoing battle?
Thank you, Paula. We have, and I know there's some FBI agents here, in addition to these gun statutes, we also have interstate domestic violence statutes, interstate stalking statutes, interstate violation of protection order statutes that we also use aggressively in our office. And in addition, I'm the liaison at the Department of Justice to make sure that all federal records are sent to the NICS background check system so that anyone who tries to buy a gun and is federally prohibited from buying a gun will be stopped from doing so. And in fact, domestic violence is the third highest reason why people are denied guns when they do background checks. And maybe in the coming weeks, there will be even more background checks being done in the state.
Thank you very much. My name is Michelle Kanyambo. I liked a sentence from your presentation saying that safety in our communities begins in our homes. Saying that I know all human beings are born with some craziness, some dosage of craziness. You don't know when someone will become danger or dangerous. Someone may born with good character. Because of circumstances, may become dangerous person. So do you believe, if you say safety in our communities begins with safety in our homes, do you think our homes are safe with more guns or are safe with less guns? Thank you.
I'm speaking here in my official capacity. So all I will say is that we really think in domestic violence cases, it is clear that victims are much safer without guns in the home, and the data supports that. So I know there are arguments that people are safer if they have guns to protect themselves, but that has not proven to be the case in domestic violence. They are much less safe if there are guns in the home. Do you have a question?
Sure. Given all the both state and federal statutes and prosecutions that have started to happen for domestic violence over the last, say, 40 years, is there a way to assess, do you think, and maybe this is an intractable question, but is there a way to assess the relative contributions of the federal steps against domestic violence versus state steps against domestic violence?
Well, it's like, how do we judge success? It's really hard to judge success. The numbers don't seem to be going down. But there could be that because domestic violence is more part of the national conversation, that more people feel comfortable reporting crimes or calling the police. And if offenders are held accountable, then they will be more comfortable using the criminal justice system. A common refrain we hear is that victims do not feel comfortable. They feel the criminal justice system has let them down. So we want to be part of that remedy.
Thank you.
So Margaret, on behalf of the University of Maine School of Law, on behalf of its Judge Frank M. Coffin Lecture Committee, and on behalf of the members of this hall, we want to thank you for your service.
Thank you. Thank you. They're beautiful. Thank you very much.